Well, good morning, everybody. We're honored and delighted to be here. And I just want to take a personal moment to thank Will Baude. This is the first time we've worked together. The incomparable Will Baude has been just an amazing person to work with. We actually met for the first time at this conference about a dozen years ago. He was a young whippersnapper, and he made his fame with his first article attacking me. And so I met him, and I said, Will Baude, my nemesis. And we became fast friends ever since, and we've exchanged drafts. But this is the first time we've worked together on anything. It was about May 2022. I sent Will an email, and I said, you know, I'm thinking of writing something short on Section 3. Have you blogged on this? Are there articles out there? Because they're just sort of intrigued by the problem. And he said, well, have you read Griffin's case? And I go, oh my gosh, yes, that's just horrible. That's just wrong. And he said, I agree. And he said, and there's, Gerard Maglioca has this article. And I said, yep, I've read that. I think he's right on point. And we went back and forth for a period of time before we realized we had the same views. And I said, should we write this thing together? And so we started doing it. And actually, so this is spring 2022. And at the time, Donald Trump does not look like he will be a candidate for president in 2024. He's very unpopular. Then he starts getting indicted, and his approval ratings go up, and all of a sudden it became interesting. But there was a long period of time when we thought this might have no interest to anybody at all. It's just sort of an intellectual exercise of trying to figure out some interesting puzzles. Then, by August of 2023, when it launches, it sort of hits big and it becomes sort of this intriguing issue that gets argued before the Supreme Court just a couple days ago. So in the next 7 minutes or so, I'd like to just sort of sketch out our argument. I'm going to try to compress 126 pages into about 3 or 4 minutes. I'm going to sketch the overall project, our theses, and then talk a little bit about how it fits within the general project of originalism, in what ways it displays originalist methodology. I assume that many of you are familiar with the arguments in general, but basically we have 4 broad propositions in this article. First is that it is legally operative. Section 3 remains legally operative. It remains in force despite the fact that it was adopted at a specific time in history and addressed to a specific historical problem. The debate culminated in a text, and we enact legal texts. We do not enact specific historical intentions at the time. So we'd say Section 3 remains legally operative. In fact, one early intermediate working title of this was Section 3 lives. So that's our first proposition, Section 3 lives. Our second proposition, which we spend considerable time on, is that Section 3 is self-executing. And by that, we mean it does not require congressional legislation in order to have legal force. Section 3 is not a grant of power to Congress to impose a legal rule of disqualification. It enacts a legal rule of disqualification from office itself. It doesn't mean that nobody has to apply it, but the legal rule exists by virtue of its enactment in the Constitution, and then it becomes a legal duty of everyone whose job functions are affected by that legal rule to apply it faithfully. So that's the second proposition, is that Section 3 is legally self-executing. Our third proposition is that Section 3 it supersedes or satisfies to the extent in conflict with earlier constitutional provisions. It's a constitutional amendment, so it amends the constitutional rules. To a large extent, it can be reconciled with most prior constitutional provisions, but to the extent it changes things, it changes things, okay? And then our fourth proposition, which is the one we're going to be focusing on and ask you to read, is that Section 3 is sweeping in its substantive legal rule. And that's the excerpt of the paper that we've asked you to read. It is, so I'm going to spend just a couple minutes talking about the meaning of the term insurrection, the meaning of the term rebellion, what it means to have engaged in insurrection or rebellion, what it means to provide aid or comfort to enemies of the United States. And Josh has graciously put Section 3 up on the screen for you to look at. And basically what the paper does is looks a lot at originalist evidence and what should count as originalist evidence for the meaning of these terms. And we sort of surround it by looking at a number of things. We look at contemporaneous dictionary definitions, both common dictionaries and legal dictionaries from the 1850s and 1860s. How did they use the words insurrection, rebellion? We look at, to the extent it yields any information, we do intratextualism, to borrow Akhil Amar's phrase. We look at the use of these terms or closely related terms in other provisions of the Constitution. It turns out that doesn't shed a great deal of light on the meaning of the terms as they are used in Section 3. We spend a considerable length of time looking at contemporaneous public, political, and legal usage of these terms. Lincoln's consistent characterization of secession as rebellion in a number of public speeches, proclamations, was very central to the identification of what was the legal character of secession. We look at congressional statutes during the Civil War in terms of their treatment of insurrection or rebellion. We look at the ironclad oath of 1862, which uses many of these terms and is in some sense a precursor of Section 3. We look at the terms as they're used in the Second Confiscation Act of also of 1862. These legal enactments that are like 3 or 4 or 5 years before the drafting and ratification of Section 3 provide kind of a glossary, a functional glossary of the terms as they finally emerge in 1866 to 1868. We look at statutes, the Insurrection Act statutes, and we look at prior historical circumstances that were sort of background understandings of what an insurrection or a rebellion was. The Whiskey Rebellion, Fry's Rebellion, Dorr's Rebellion in Rhode Island, slave revolts and anti-slavery mob actions, and John Brown's Rebellion. So we sort of look at all of these sources as evidence of the original meaning of the terms as they're used. What we come up with, do I still have a couple minutes?
You have 2 minutes and 9 seconds.
In 2 minutes, let me tell you what we conclude insurrection is. This is all in the paper. Our understanding of insurrection or rebellion is that they are overlapping in very similar terms with distinct shades of meaning. Our understanding of insurrection is that it involves concerted, forcible resistance, not to just the laws, but to the ability of the executive to carry out the laws. It is resistance to more than a particular law. It is resistance to the authority of government. It differs subtly from rebellion in that it doesn't so much imply an attempt to displace or replace the government. Rebellion has more the characteristic of attempting to substitute one legal authority for the existing legal authority in an unlawful manner. And the paradigm cases that the historical evidence supports would be secession, and we submit coup d'etats. If the action is essentially an attempt to overthrow in whole or in part the prior constitutional order unlawfully, that counts as a rebellion. What does it mean to have engaged in insurrection or rebellion? And the sum of the historical and textual evidence we find is that the term engaged in embraces a wide range of active participatory conduct. It can consist of meaningful acts of support, encouragement, endorsement, as the term was used in 1860s discourse. Engaged in, embraced a lot. This is reinforced by the language of aid or comfort, which seems as much to define, it is almost like it is a loophole closing expansion of the prior prohibition in order to make sure that you do not evade the prohibition by artful use of terms. And we'll talk more about enemies and when you get to questions, but I'll leave it there.
Well, thank you so much. It's a pleasure to be here. I'm sorry Seth couldn't be here. We were in D.C. on the arguments for Thursday, but Seth couldn't make 2 cross-continental trips in about 3 days. So we start with the basic text. The Constitution in 4 provisions uses the phrase officers of the United States. I know this is small: the Appointments Clause, the Impeachment Clause, Commissions Clause, and Oaths Clause. The phrase office under the United States is used in the Elector Compatibility Clause, the Impeachment Disqualification Clause, Incompatibility Clause, and the Foreign Emoluments Clause. Most people look at these and didn't give these phrases much thought. But then there's Seth, who I've gotten to know very well over the past decade. And starting in 2008, Tillman started writing that the phrase officer of the United States in the Constitution means people appointed, not the elected president. And that the presidency is an office under the United States also. Seth persuaded me around 2013. I was Tillmanized, as one might say, and I realized that he had something. He was onto something. He was looking at text in a way that really no one else was. And in fairness, my good friend Will Baude reviewed Seth's work in 2016, and he said, Tillman's theory makes sense of patterns that most of us never saw, brings order out of chaos. And I think Will was exactly right. Indeed, before I embarked on this journey with Seth, I actually asked Will, I was like, Will, do you think I should do this? He's like, yeah, I think Tillman's got something. So it's kind of a Will's fault in a way. So starting in 2017, we started thinking about the Foreign Emoluments Clause. As people know, President Trump had a number of business interests, and he was accused of engaging in illegal emoluments. Now, this is not about what emoluments means. We can talk about that. But the key phrase is office under the United States. And over the course of 4 years, Seth and I were on a sort of a mission. We filed a number of briefs in courts arguing that this phrase office under does not include the president. We have textual evidence. We have evidence from George Washington. He accepted gifts from foreign governments, from France. Thomas Jefferson accepted foreign gifts. We have the much vaunted Hamilton document, where Hamilton was asked to do a list of those who hold office under the United States. He did not include the president upon that list. And that created a bit of a storm. And Seth got his first New York Times profile because of a kerfuffle with legal historians, who I'm very good friends with now. Because we had something, right? We had this document from Hamilton which suggests that the president is not an office under the United States. But really, frankly, no one cared, right? This didn't get much attention in the courts. Only one judge really addressed it, and he rejected our argument. So be it. 4 years ago, almost to the date, Seth and I were sitting, well, not here, but we were at the USD campus, and we presented a paper called Officers of the Constitution. And we thought, this is kind of a fun paper. We're going to walk through all 7 articles and all the references to office and officers. And this is what Seth and I looked like 4 years ago. COVID did not do us well. It was a long span. And, the paper's received, I think, okay, middle. We weren't quite ready yet. We hadn't given it all the thought we should have. We thought, we are onto something. Okay. The emoluments case went to the Supreme Court. Cert denied. Case over. We thought, we are done, right? We are out of the thicket. We can now talk about emoluments without regard to Trump, thank God. But then, oh boy, January 6th happened. And on January 6th, both Seth and I independently realized, oh crap, officer of the United States, office under the United States. Because the only way that Section 3 applies to Trump is if the president is an officer of the United States. And the only way Trump can be disqualified if the presidency is an office under. Now, maybe Mike thought that Trump wouldn't win. I did. I thought on January 6th he was a leading candidate for president. I thought that immediately. I said, okay, we are now stuck in a Groundhog Day loop where we cannot escape offices and officers of the Constitution. Seth and I started writing this on January 7th. We actually were writing immediately. I had a long list in Volk. You can see all of our posts. And we published in 21 a paper in the NYU Journal of Law and Liberty called Is the President an Officer of the United States for purposes of the 14th Amendment? And we argued that he is not. And then for some time, there were a few responses from Gerard Magliacca, from Miles Lynch. A few people disagree with us, but there wasn't anything sustained because the litigation was going nowhere. But then my good friends Mike Paulsen and Will Baude were in the New York Times themselves, lots of New York Times launches. And they made the case as the leading scholars to say why Trump should be disqualified. They talk about us briefly. If you notice in their little notation, here are 10 paragraphs about Blackman and Tillman. 10 paragraphs. We wrote 250 pages. We got 10 paragraphs, right? And Mike and Will have this one line. The Tillman-Blackman textualist approach is hidden meaning hermeneutics. I had to look that word up. That renders Section 3 a secret code loaded with hidden meanings discernible only by a select priesthood of Illuminati. Now, an Orthodox Jew being an Illuminati priest, you figure that out, but I'll let that one go. I will give you all secret decoder rings later so you can figure out our theory, and we will have you in the box of Cracker Jacks, right? Akil Amar, whose name's been invoked a few times, said, oh, this is my favorite. Let me be clear. Akil, we're laughing at you, not with you. Let me be clear. This is a genuinely stupid argument of the merits. I'm going to demolish it. It's embarrassing. This is very wrong. It's silly. It's silly. I was laughing because I actually can resist even formulations and list laughter. He and Ketanji Jackson have a lunch that might be worthwhile to have. Okay, so look, our theory was not well accepted. I get that. I'm going to now try and defend it. Why? Because a trial judge in Denver, not a FEDSOC member, not an originalist, agreed with us. She agreed with Mike and Will on virtually everything else, that there was an insurrection and so on. But in 5 pages, she wrote an opinion saying, yeah, president's elected, not appointed. This phrase means appointed. And I'm like, okay, yes. So someone actually sort of endorsed it with a robe. The Colorado Supreme Court, as we all know, rejected that decision. And for those who read the entire decision, they spent only a couple pages in the office issue. Said, well, this is silly, this is odd, this can't be right, so we're going to reject it. They didn't actually discuss the appointments clause and so on. All right. Supreme Court grants certiorari. Tillman and I put a brief in. We also tried to seek argument time. It was denied. Maybe it should have been granted, but we'll leave that there. All right, so the case goes to the Supreme Court. Tillman gets yet another New York Times article. I don't know how many people get New York Times articles multiple times. A legal outsider, an offbeat theory in the favor of the election. Trump's lead argument, at least on the brief, was us, right? The stuff they put forward was stuff we've been writing about for years. So this is me and Tillman at the Supreme Court. I love this picture. We're looking off into the gaze. This will be in a book jacket one day, by the way, if you're curious. Just a before and after Trump. This is the. But I want. So that looks great. Yeah, Tillman doesn't, right? Blackman doesn't. Anyway, so he looks the same. So I want to try and just my remaining 3 minutes opening statement, give you 3 approaches that came up in argument of how to approach this issue. So we have Justice Kagan, we have Justice Gorsuch, and my new best friend, Justice Jackson. And so approach number 1 is Justice Kagan. And she said, okay, is the president offered to the United States, we ask ourselves, is this rule sensible? That's the key word. Is it sensible? She used that word, and I'll come back to Will in a minute. Gorsuch nailed it, by the way. When Gorsuch is wrong, oh, he's wrong. But when he's right, he's on fire. And that's my view of Gorsuch. Sorry, Stephanie. Right, but when he's on fire, no one can touch him. And he said, you know what? So maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer. That is, between office under the United States and officer of the United States. But maybe that's exactly how the Constitution works. And I'd put that in a bumper sticker if I could. Then we have Justice Jackson, who again, came out of left field, you might say. I didn't see this one coming. But she said, the history of the 14th Amendment actually provides the reason for why the presidency might not be included. So, okay, so we have Kagan, number 1, Gorsuch, number 2, Jackson, number 3. All right, let me just switch the faces. Whoa, see that? They did it again. Whoa. So Kagan is with Will and Mike. And I'll prove this in a minute with her paper. Is the rule a sensible one? What is good sense? Gorsuch is Blackman Tillman, right? He accepts our position almost in its entirety. And then where's Kurt? Hi, Kurt. Kurt is Justice Jackson. Justice Jackson was cribbing from Kurt's brief. And I think I've actually gotten some credit for this. Actually, it's Kurt's brief that Jackson was asking about, so I want to make sure Kurt gets all the credit he's due. But Will, in their paper, and again, Kagan sort of, Jonathan Mitchell, the lawyer for Colorado, the lawyer for Mr. Trump, actually praised Will's paper and said, yeah, Will might make a good point, and Kagan agreed. So Will say in their paper, it's far more sensible, that's where it's sensible and straightforward to conclude we think that the office holder holding the office of president is an officer of and under, blah, blah, blah. And I call this sense and common sensibility. they only had 10 paragraphs on us, but at least 6 of them use the words common sense in it. They keep saying over and over again, this is common sense, it makes sense, it's plausible, it's sense and sensible. This is the argument. What is common sense? And you guys are all legal theorists. Common sense is what we're left with. So again, I will leave you with Justice Gorsuch's point. I want to focus on this, right? There's text in the Constitution. Maybe we today, us moderns who are not steeped in British parliamentary drafting conventions, don't get it, right? And we look at this doesn't make sense, Tillman's crazy. But if you look at it, how someone in the 1790s have looked at it, they had a different frame. They study in the English Inns of Court. They trained in England. They learned things that we just don't know today. The various committees at the convention made surgical alterations to this language to make it consistent, to make sure that offers to the United States have the same meaning in each provision. Office under had the same meaning. We may not know this today. We think it was known back then. I'll close with Justice Sotomayor, who had, not her best day the other day, but she said, you know what? I object to this argument. Why? It's a bit of a gerrymandered rule, or gerrymandered, if you will, because it's designed to benefit only one client. Why? Because only Trump would benefit from this. He's the only president in American history to take no other oath. And Mitchell said, well, it's not gerrymandered. That implies nefarious intent. We are not nefarious. We are loving, right? But Sotomayor said, well, you didn't make it up. Some scholars have been discussing it. Some scholars. So you know what? These are some scholars, and I'm damn proud of it. Thank you so much.
All right, let me first say I too love Seth Barrett Tillman. When I was writing my very first article attacking my now co-author, it was on SSRN, and I was clerking for Michael McConnell, and the chambers kept getting these random calls from, and the judicial assistant screened them out because the caller, she didn't know who he was. And one day she was gone, and the call rang through the clerk's office, and I picked it up, and a voice said, Will, it's Seth. We need to talk. I have comments on your paper. And then he said, are you ready? I said, okay. And then an hour later, I had taken notes, line by line about many things on the paper he thought were wrong, some of which he was right about, some of which we continue to disagree about. And he's a brilliant and insightful person. That said, I don't know that his brilliance and insights carry through to Section 3 of the 14th Amendment. So, as Josh has said, as people will know from his other work, Seth has a lot of work trying to put together all the different parts of the original Constitution and its uses of the phrase officers of the United States, officer of the United States, office under the United States, officer, etc. And there are basically two ways you can think about the original Constitution. One is to think there is some consistent usage for all these terms, which leads to some surprising conclusions today, but maybe you could piece together all the evidence to show that while your initial intuition might have been that the president is covered by the Foreign Emoluments Clause, it's not because it uses this phrase over here. And you can sort of find this pattern. You can bring a pattern out of chaos, I think I once wrote. Or you could think that the meanings of each of these phrases depend on the context of each clause they're in. And so the way to think about officer of the United States in the Commissions Clause might be different from the way you think about it in other clauses and so on. I think those are sort of the two competing theories about the original Constitution. And I think until Seth came along, it never occurred to anybody there was a consistent pattern you could find in everything. Seth put together in a series of many articles and different pieces of evidence, at least a proposal for a pattern that's plausible. That, again, makes sense in some ways, leads to surprising conclusions in some ways. And I think, although this term has now been maybe caused more offense than intended, I think it is fair to say that Seth basically proposed that he was decoding a secret code in the Constitution. Not secret to its authors, the theory is they knew it, but that until somebody came along and showed you how all the pieces fit together and showed you these forgotten British parliamentary drafting practices and the things they knew that we didn't know today, until somebody brought you the key, you wouldn't be able to find the pattern until you worked through everything together. I remain agnostic on whether that's actually correct about the original Constitution. I think it's very plausible. It's impressive how plausible it is. I think other people in this room have taken the position that it's still wrong, but that's where we start. But I don't think there's very good evidence that it carries through to the Section 3 of the 14th Amendment for a couple reasons. One is a lot of the evidence of the 1789 secret code itself changes over the ensuing decades. So it is the case that George Washington took foreign gifts, which appear to us to be foreign emoluments, although I don't think they were ever described that way at the time. But then it's also the case that subsequent presidents in the 1820s and 30s stopped taking similar foreign gifts, believing they were covered by the Foreign Emoluments Laws. And the originalists point out, for purposes of the 1789 Constitution, that's not that relevant. Maybe like the original meaning was lost sometime in the 1820s or 30s. The same thing for the drama about Alexander Hamilton's list of officers, where there's an original document written by Alexander Hamilton that cuts one way, a later document written by a scrivener of the American State Papers sometime in the antebellum period that cuts the other way. Again, as an original matter, that's a very fair point to say, like, Hamilton probably knew more about the original Constitution than some drafter in Congress 20 or 30 years later. But Section 3 was written by drafters in Congress 60 years later, 70 years later. So we want to know what their interpretive context was and what they were thinking about. And the very fact that the argument is that this usage comes from those steeped in British parliamentary drafting practice, that they knew things in the 1790s that we don't know today, and so on, I think provide extra reason to think that the drafters of Section 3 of the 14th Amendment had lost the key to whatever this secret code was. And the evidence that they knew about the possible technical meaning you could assign to all these various terms is very weak. That's especially true for the phrase office under the United States, where there are a lot of people contemporaneous with Section 3 and right after Section 3 thinking that office under the United States applies to the presidency, and the repeated trope about whether or not Jefferson Davis can or can't be president based on whether amnesty bills passed. I think there's a lot of evidence that office under no longer had the Tillmanized meaning, if it ever did. And once that's true, the reason to think that officer of the United States in the same thing did retain its Tillmanized meaning without very much direct evidence of that, I think is very weak. And that's why I think we should remember to approach Section 3 as originalists, from the point of view of its drafting context in the 1860s, not by trying to sort of put it into a time machine and imagine that it was drafted by Alexander Hamilton, or imagine that it was drafted by people with Seth Barrett Tillman's scholarship about Alexander Hamilton at hand to understand its meaning. And that's what leads us to think that as a matter of what I guess we dangerously called common sense, the more technical or specialized meanings of the phrase that you can arguably draw to the original Constitution are quite implausible. Thanks.
Okay. Thank you so much. So I think Will and I actually agree on a lot. I think Will, maybe not Mike, but I think Will at least agrees with Tillman's having a plausible argument on the Constitution of 1788. Tillman in 2012 wrote that he wasn't sure about Section 3 in office under the United States. He said that in 2012. I know people have said, Tillman, why are you taking a position? He took that position in 2012 because he said the Jefferson Davis argument, right? There's nothing new about this. And in fact, in our paper, we acknowledged that there was probably linguistic drift on office under. And the evidence is the Hamilton document. The version that was actually modified, that people read, included the president. So that, okay, the president's office under the United States. So actually Hamilton helps us in both regards, the real document and the modified document. But an officer of the United States, I think we have our evidence against linguistic drift. There's a long stream of cases from the 1800s on saying that the phrase officer of the United States is appointed. How do we know this? The Appointments Clause. You all teach common law, at least most of you do. We know that the Appointments Clause refers to those who are appointed by the president or the heads of department or the courts of law. Every executive branch opinion looked at it said the phrase officer of the United States means appointed. And if you want to ask me appointed, elected, I can answer that later. I don't think that's kind of a red herring. But we all understood this phrase means appointed. There's Joseph Story, who looks at the Impeachment Clause, right? And he's observing the Blount case. He's not saying perhaps his best opinion. He's observing the Blount case, that when the Impeachment Clause says the president, the vice president, all civil officers, they're separating the president and the VP. As Kurt has shown, Story was read widely. They all read Justice Story. We have decisions from the Supreme Court in the 1870s, 1880s saying the phrase officer means appointed. So it's not as if this meaning was lost. This is not based on ancient British drafting conventions. They read the Constitution. It was only until recently people started saying that the president is an appointed official by the Electoral College. That's an argument that's come out recently, but that was not how it was viewed for the longest of time. Now, on the point of whether there's a Tillmanized meaning, we found some evidence, right? There's not a lot of evidence on this. There's a lot of evidence, Velopoulos and Graeber have shown, that people thought office under meant the presidency. I'm not going to challenge that here. But if you read the corpus linguistics paper by Halpern and Worley, they say at the end of their paper, we've found no evidence that anyone ever said the president's an officer of the United States. No evidence at all. They tried, trust me, they tried. They didn't find anything. Maybe Andrew Johnson says, oh, I'm the chief civil officer of the United States or the chief executive officer of the United States, these various variants. But the key phrase is simply not there. So then what are we left with, right? The Supreme Court now is a case of first impression, right? We don't know why the framers used this phrase, officer of the United States, in Section 3. Now, Till and I have a theory, right? Section 3 is based on certain positions who take oaths, right? If you took a certain oath, you're subject to disqualification. If you look at the positions listed in Section 3, they match up almost perfectly with those in the Article 6 Oath Clause, right? Senators, representatives, right? I'm sorry, wrong one, Article 6, sorry. Senators, representatives, members of legislatures, executive officers of the United States and the several states. It's almost perfect match. Our theory, which is perhaps as plausible as any, is that those who framed Section 3's Oath Clause borrowed the language from Article 6, right? So it wasn't that I'm using a time machine. You had people who were steeped in the law, who read the Constitution, said, okay, we have to draft a provision applying to people who take oaths. I have an idea. Let's use the same language in Article 6. Let's bring that meaning with us forward. Let's carry forward that old soil, to use Justice Frankfurter's words. And when you carry forward that old soil from 1788, you get the Tillmanized soil, right? Maybe the tilled soil, if you will, right? You get that soil with you. And if the president was not an officer of the United States under the Oath Clause in Article 6, then he's not an officer of the United States under the Oath Clause in Section 3. And you don't have to take my word for it. We found one piece of, actually we didn't find it, a guy named John Connolly found it, it's quite good. It was a newspaper from Louisville, Kentucky, from April of 1868. That is smack dab in the middle of the ratification period, April 1868, right? Someone said, oh, it wasn't the right month, give me a break. It's April 1868, close enough. And there was a debate about what officer means. And one newspaper said, well, you know what? The president's not an officer of the United States because he's enumerated separately in the impeachment clause. He's not in the commissions clause. He cited the same evidence we're doing. So anyone in 1868 took 5 minutes to think about it would see the same thing that Tillman saw. There was another newspaper from Cincinnati across the river, right? And that newspaper said, this is harebrained linguistic splitting. Basically, it's just not common sense. This is the secret code. The same arguments that Will and Mike are making today against our position was made by a newspaper in Cincinnati. So the debates we're having now are not new. In 1788, can a senator be impeached or not? In 1868, is the president officer? In 2024, is the president officer? You have the exact same debate. So the question is, what methodology do you choose? Common sense and sensibility, right? Where each clause is a clause unto itself based on context. Is that originalism? Is that textualism? Or we try and look at the Constitution as a cohesive whole, and we see how each clause interacts with every other clause, how there's consistent patterns, how the Constitution, as Gorsuch said, couldn't work otherwise. Right? The question is not, is Tillman right or wrong? It's which approach do you choose? We have cleared any bar about plausibility. I think we have. And the question is, how do you do it? Now, look, I know Mike told me not to do this, but I will, right? We have the Supreme Court deciding a case right now on basically what are works in progress, which aren't works in progress. Both our papers are done. Let's just be honest here, right? So our papers are done, and I said before, Mike and Will bent the arc of history, right? They did. But for their paper, I don't think the Colorado court would DQ Trump. I mean that sincerely. And maybe the Supreme Court will take a punt. They'll say, oh, Griffin's case, which hasn't been mentioned yet. Maybe they'll say we need a national solution or so on. But this issue is not done, right? Why? Because if the court takes an off-ramp and Trump wins the election, let's say, which is possible, and let's say the Democrats have majorities in both houses, guess what happens on January 6th? Will and Mike updated their paper, and they said, you know what? We're not so sure. It could be that Congress could say on January 6th that Trump's votes are not regularly given. So the office issue ain't going anywhere. It's not going anywhere. This might go back to the Supreme Court. I don't know how, but it'll go back to the court anyway. So again, this is a work in progress paper, but these issues are baked in, and they have very high stakes. So I love academic discourse. I love debates. We should recognize the consequence of the sort of the secret code or ring position and sort of what it might mean. All right, I'm at 7 minutes. Thank you so much. We have 90 minutes of questions ahead of us, so I thank you all for your time.
Okay, so this is, I guess, questions for Josh. I guess 3 quick bits. So I've spent, maybe 10 hours looking through the legislative history of the 1868 Act act to readmit Florida and Georgia and the Carolinas and Alabama and Louisiana. And there are a bunch of discussions on June 8th, 9th, and 10th about the self-execution issue. These are the same pages that Akhil Amar cites in his brief, very, very, very briefly, on the self-execution issue. So it seems like that explains the existence of that statute differently from how your paper for this conference explains it. So I'm just curious if you have any reaction to that. Secondly, I'm curious, and I guess I'm curious what Will and Mike think of this. Cohen's versus Virginia. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. So treason by omission seems like it's a thing in 1821. Could you have comfort by omission? I dare say the people in the Capitol on January 6th, the fact that Trump had said nothing was quite comforting to them for at least a bit. Third, I'm curious about how this apex executive idea deals with governors. So in 1868, oh my goodness, there's, if you're having a drinking game, every time the Democrats mention Governor Holden of North Carolina being subject to Section 3. So, I mean, Section 3, it chops up these phrases in a way that makes it really seem like this is compositional. So the meaning of these phrases depends on the meaning of the constituent parts. So office under the United States or under any state. So if a governor, if an elected chief executive of is an office under a state, in Article 6, it's got to be an executive officer of a state too. Why would you have a difference for the feds instead of the states, unless it's some sort of holistic view where it was completely different? But that doesn't work for the 14th Amendment. So.
Great. Thanks. I think this is a great format that we've got plenty of time to discuss this. And also, Josh, we had a great debate on my home turf.
We did. Thank you.
And thanks. I appreciate your engagement and your good-naturedness about this whole thing. So, and I was on a run this morning. Something dawned on me, and it comes back to your. This is for both Will and Michael. Your Part 3 on Section 3 is missing Article 3. And what dawned on me this morning is that this was not a new problem of insurrection or rebellion in 1787. One of the main reasons why the Constitutional Convention happens is Shays' Rebellion. And what's interesting is you have a sentence, I'm sorry I can't find it now, you've got a sentence where you have a chronological order of rebellions that happen up until the Civil War, but you've got an accidental flip. You say the Whiskey Rebellion, the Shays' Rebellion, and then John Brown's, and that's right, the Rhode Island Rebellion, and and it's a bit of a Freudian slip in a way, because you have put the Shays' Rebellion after the Whiskey Rebellion in that sentence. The fact that the Shays' Rebellion happens and then they draft Article 3 creates a problem about what the concern I've had since the beginning about this argument, which is how do we understand as a matter of original public meaning what is insurrection or rebellion? If the Shays' Rebellion was understood to be a rebellion, their Article 3 cuts in the other direction. The Article 3 limits the capacity to punish treason or rebellion by putting rules about two witnesses to the same acts. And so, and it also comes right after, the idea that all crimes shall be by jury in the previous. If we're doing an intertextual reading, it seems to me that what this suggests is that when something is the size of Shays' Rebellion, it has, we need to be worried about the over-criminalization of those kinds of activities. But when something is Civil War sized, that creates a manageability problem where it's just, we've got too many rebels with a civil war. There becomes a necessity to expand it. So if something is Shays' Rebellion size, it's Article 3. If something is conflagration civil war, that's Section 3 of the 14th Amendment. And you can have criminal process for Shays' Rebellion size things, and only something like Colorado could apply if you had a Civil War type thing. And so I think that gives us at least a little more grounding to understand the differences in American history between smaller rebellions and Civil War insurrections. And I'll save the question for Josh is, you keep going back to the appointments clause. If you could just put that back up on the PowerPoint.
Happy to do it.
You keep underlining the part that's most convenient for you. If you keep going past all other officers of the United States, comma, whose appointments are not herein otherwise provided for, and which shall be established by law. That distinguishes, that's text that tells us that all other officers of the United States whose, the next two passages tell us that it doesn't relate to the president, because presidents and vice presidents have appointments who are otherwise provided for, and they are not established by statute. They are already established by the Constitution. So I'm still perplexed, and for reasons that Sam Bray has brought up, is that there are other linguistic reasons why the appointments clause is not good evidence for you.
Happy to address that. Thank you.
Great.
Cy.
This is a question for Mike and Will. So I've got two friends, Will Paulsen and Mike Baude, and they are textualists, they are amiable, and they are brilliant. And they read Section 3 and they say, look, it's about serving as president, not running for president, not being elected to the presidency. And then they know the history, and they know people were elected to office after the 14th Amendment, but could not serve until the disability was lifted. And then they say, yeah, maybe there's this thing called Article 2 that suggests that states can just do whatever they want with respect to the electors. That's true, but that's an argument that has nothing to do with Section 3 of the 14th Amendment. And if you are right, all the work's being done by Article 2. And so if it's permissible to remove Donald Trump from the ballot, it's permissible to remove Joe Biden from the ballot just because he has the name Biden, or because he served as vice president under Barack Obama. There's just no restriction to the kinds of ballot access rules that states can apply to presidential candidates. And so they're sort of more textual than you are, and I want to know what you would say to those two fine gentlemen.
Okay, so I'll start with Chris's argument, the second one about the governors. We get this a lot. If you look at Article 6, right, it refers to members of state legislatures, executive and judicial officers of the state, and the several states. The question is the governor an executive officer of the state, of the several states? We've never said this phrase, officer of the United States, means appointed in both the federal and state system. We think the Appointments Clause defines who are the officers of the United States. When the Constitution was ratified, some governors were elected, some were appointed by the state legislatures. The Constitution has a broad understanding of how states construct themselves. So a governor would be an officer of the state for purposes of Article 6. And with the Tillmanized soil again, a governor would be an officer of the state and office under the United States. We've never said that this phrase for the states is different. Okay. Let me turn now to Jed's question about the clause. There's history here about why the language says what it says. We talked about this in our South Texas paper, Part 3. Earlier in the convention, the Congress had appointment power, that the legislature could appoint judges, and at one point that they can appoint treasurers. So there were appointments provided otherwise, right? You can have a treasurer appointed by the legislature, and the legislature appoint judges. That was removed. And the understanding was that the president would appoint all the officers. So the reading that Jed gave, that there's this other body of officers who are appointed, made sense when the other branch of government had this power. But later in the convention, the phrase I underlined, and which shall be established by law, was added, which makes clear that whatever these officers of the United States are, they must be established by law. Now, I'll just get the elephant in the room, Justice Scalia, right? In 2014, Noel Canning was decided. And Justice Scalia's opinion said basically that, this phrase, the Appointments Clause and recent appointees, there might be some other officers, right? He left it open, didn't really explain what he was talking about. Tillman wrote a letter to Scalia in 2014. Seth wrote actually lots of letters to Scalia over the years. We only published this one, right? And Seth asked, we don't have the original letter Seth sent, but Seth asked Scalia, do you think the president is one of the officers who falls in this language, is not otherwise here and provided for? And Scalia wrote back with his usual gruff manner, a 2-sentence letter, saying, I meant what I said. You hear him saying it, right? I meant what I said. And he listed 4 positions that fit in this category: the president, the vice president, the speaker of the House, and the Senate President pro tempore. Now let me ask you a question. We didn't have to publish that letter. We didn't have to. No one's ever known We publish it for a reason. One, we're scholars. We have a duty to the truth. But two, we want to illustrate why Scalia was wrong. And I can explain this very quickly. This came up with the argument, actually. Gorsuch asked about this exact point. If the Speaker and Senate President pro tem are officers of the United States and maybe office under the United States, they're incompatible, right? You have the incompatibility clause. A member of Congress can hold any office under the United States. If the Speaker and Senate President pro tem are offices under the United States, they're incompatible. The respondents walked into the door. They accepted the Scalia letter, and they rendered every speaker in American history unconstitutional. So no, the Speaker and the Senate President pro tem are not offices under the United States, okay? Now, you say, okay, this language, the Appointments Clause, refers only to the President and the VP, right? But the key phrase is, and which shall be established by law. If there are these other positions floating around elsewhere, that's be established by law. The President's not established by law. But look, I don't have to persuade you on this. The Appointments Clause is a mess. John Marshall said, with all respect to the framers, we don't really know what this means, and I'll accept that. This is a very messy text. There are 2 centuries of precedent saying that the Appointments Clause means appointed by the President or the heads department of the courts of law. The idea that this language is trying to tell you that the President's actually an appointed officer of the United States strikes me as not the most likely reading and one that's never been accepted before. Okay, I'm good.
Treason in the Constitution, I think it is correct that, and while an omission is not usually culpable or a form of engaging in these various activities, an omission by somebody who has a duty to act can be different, and that's what John Marshall's talking about. Failure to act when you have a duty to act can be very culpable. Shays Rebellion, which we decided for reasons of space, believe it or not, didn't need to further bulk up the insurrection section, although it's an interesting example. I think it's a mistake to try to read the treason clause and section 3 as if they were 2 rules enacted together to govern different scales of insurrections. That's your suggestion, Jed? Because section 3 grew out in part of dissatisfaction with the treason regime. Like at the time of the Civil War, the main thing they could call this was treason. There was a widespread sense that making it a crime was not practical, not what they wanted to do, and that in some sense at the time, section 3 was thought to be maybe even a lesser stigma than just executing everybody who'd committed treason in the South, which would be most of them. And instead, the idea was we can have, instead of treason, an alternative is participation in insurrection or rebellion, not formally labeled treason, will result in disqualification. So I think the right way to see it is section 3 is the more practical, less bloodthirsty punishment enacted to amend Article 3's experience with the problem of insurrection before. Maybe because we had a different view about how to deal with insurrections. As to Will Paulsen and Mike Baude, I think all we'd say is Section 3 is a rule of qualification for who can be president. So it applies anytime the law asks us to judge qualifications. And that is a question of state law. It's right, states don't have to say that you have to be qualified to be on the ballot. I think they're entitled to send Zebulon Vance up to Congress and hope he gets amnesty. But they also can. And they aren't required to go further and say, we're going to kick Joe Biden off the ballot too. If state law asks a question of whether the president is qualified, as it apparently does in Colorado, then Section 3 answers the question whether the president is qualified. So I don't think we take the view that of its own force, Section 3 creates rules of election law or ballot access. It creates a rule of qualifications that states are legally allowed to ask.
Yeah, I don't think I have that much to add to that, but I want to respond to Cy by asking a hypothetical. Could Texas just refuse to put Biden on the ballot? And I think the answer is yes, right? I think they could just appoint electors for Trump or the Republican candidate on their own. So I actually think the question of what is the constitutional power of states to limit in choosing the manner of electors is a kind of a red herring. It's a separate question from qualification, right? Our argument is that the president, that Trump is legally disqualified from running for office again, okay? States may enforce that disqualification anytime state law provides an occasion for judge qualifications. I think they have a broader power in terms of manner of election, but I think that if they exercise it through their election process, and they can impose this disqualification where they have a legal, where it legally applies.
Yeah, well, congratulations to everyone for absolutely terrific papers that have deserve the attention they've received. So my question is about the relationship of officer stuff to originalist theory. And so, and it's a question really for all three of you, but here goes. So, how do you reconcile sort of the Tillman, Blackman close reading of the phrase officer of the United States with public meaning originalism? And in particular, is it plausible to believe that ordinary citizens would have attributed this highly technical and complex reading to the clauses, given the difficulty of parsing the various provisions so as to produce this coherent, but I think even at the time, slightly counterintuitive result. And then the sort of the flip side of this question, and I suppose this is mostly directed towards Will, is how do you resist the technical reading that seems to be deeply rooted in the original law of constitutional interpretation, or alternatively, the original methods of constitutional interpretation, which seem to highly value constitutional interpretations that produce consistent meanings for the same words and phrases when they appear in multiple places of the Constitution. Isn't the Blackman Tillman approach the approach that would be most consistent with original law originalism?
Good question.
Okay, so I want to ask a question. I put a blog post on this a couple of days ago, and it's about the relationship between Section 3 and the First Amendment. What happens if Section 3 is inconsistent with the First Amendment in some respect? Now, what you guys say is, if you can read them together, great. If you can't, you should go with Section 3 because that's later in time. And I think that's right as a general principle, based on the traditional rule, which is that, you know, repeals by implication are disfavored, so you should try to read them together, but if you can't, go with the later in time. Now, I read you as saying something a little bit more precise than that. I read you as saying you ought to look at Section 3 and look at the originalist evidence, look at Section 3, mainly in isolation. And if the better reading of Section 3 is A, we go with A. And if that's inconsistent with the First Amendment, well, so much the worse for the First Amendment. It's later in time. And I don't think that's quite right. So what I would say is you look at, and it's not right in a certain circumstance. So if the better reading of Section 3 in isolation is A, But a pretty good reading of Section 3 is B. And A conflicts with the First Amendment, but B does not. Then it seems to me you read the two together and you go with the reasonable reading because that does not repeal by implication the First Amendment. And I don't read you guys as saying that, but I guess I wanted to ask, do you think that? Do you disagree with that application?
So my question is for Josh, and it's about the officer of the United States question. And it grows out of research that I've done for many years that predates the Emoluments Clause litigation and predates the Section 3 issue, and is related to the officers of the United States to which the Necessary and Proper Clause refers. But I'm not going to talk about that. The research I've done grows out of that topic, but I'm going to talk about things that are more germane to this issue. I had the good fortune of being the commentator on the paper that you and Seth presented at this conference several years back. And it was a good fortune because it forced me to actually dig deeply into the network of arguments and inferences that you have constructed around this issue. And at that time, I pointed to three areas where I thought the argument was weak. One had to do with the Necessary and Proper Clause. The other had to do with the blunt impeachment, which I think is subject to very different interpretations than the one you give. And the other was basically the Scalia point with respect to the Appointments Clause. But in this question, I want to focus on still other issues, because at the end of the day, I'm not persuaded. I am persuaded that there's a plausible, interesting theory that you've put together, and I think it's very admirable, the work you've done. But let me ask you just a couple concrete questions about the original understanding of two of the clauses at issue here. One is the Article 6 oath, and the other is the Commissions Clause. When John Adams took his oath of office as the first vice president, he did so pursuant to Article 6. He was not an appointed official, but an elected official of the government of the United States. If I understand you correctly, you and Seth think that the constitutional source of Adams's oath was the Rules and Proceedings Clause of Article 1. But the First Oath Act, on its face, refers to Article 6. This is the very first act the Congress of the United States under the new Constitution ever passed. It was adopted unanimously. It was signed by George Washington. It's a public event. And it refers on its face to the President of the Senate, but that's John Adams, and he's an elected official of the government. So that's sort of question one. How do you actually square your theory of the Article 6 Oath or Affirmation Clause with the way the oath was actually implemented the very first time Congress passed a statute and the way it was applied to Adams? I don't think it's an out to say that technically Adams took his oath as the president of the Senate, not as the vice president, because then the president of the Senate is going to be an officer of the United States. And you have to fit that into the language of Article 6, and that's hard to do. I think the best understanding of what happened is that Adams was understood to be an executive officer of the United States, but elected, not appointed. So that's one counterexample to the thesis. The other has to do with the Commissions Clause. So the Commissions Clause says that the president shall commission all the officers of the United States. That might lead you to think that every officer of the United States is commissioned by the president. That's never been true, and it wasn't true from the very first moment of the formation of the government. So let's think about inferior officers of the United States. The first Congress passed statutes creating inferior officers of the United States. And in point of fact, Washington didn't commission them. So let me give you two examples. John Tucker, a man named John Tucker, was the first clerk of the Supreme Court. He was not appointed by Washington, he was appointed by the court. pursuant to the First Judiciary Act. When he is entering into office, he takes 2 oaths. One is the statutory oath imposed by the Judiciary Act, but the second is an Article 6 oath as a judicial officer of the United States. He was not commissioned by George Washington. It's not clear he even got a commission, but he is plausibly an inferior officer of the United States. Second example, and the last example, is Tench Coxe. Tench Coxe is the second Assistant Secretary of the Treasury. He's a very plausible candidate for an inferior officer of the United States. He's appointed by the head of department, Hamilton. Hamilton gives Coxe his commission. Washington doesn't give him his commission. So it looks like the original practice was actually not in conformity with the strict text of the Commissions Clause. It looks like the original practice amounted to something like, the president shall commission all the officers of the United States whom he appoints. And you could do this research, you could go deeper into the history, right? So all those deputy collectors who are revenue officers, they're also officers of the United States. Later statutes sweep them in. But they were not commissioned by the president either. He commissions the principal officers, not the inferior ones. So it seems to me that Sam Bray was right, which is to say the pragmatics of the situation was well understood to the founding generation, both in the drafting of the Constitution and how it was implemented. It was a slightly different meaning than what would be taken today if you just look at the text and you don't look at the actual history. But everyone understood that Adams was an officer of the United States. Everyone understood that Tench Coxe was an officer of the United States. And so that argument, I don't think, does the work for you that you've suggested. I'll stop there. There are other examples like this that I think if you dig into the history, we have to come to grips with the fact that the original understanding that Larry's talking about is just different from the original semantic meaning that you might draw if you just focused on the text. And I think that's a big weakness for your argument.
So let me start with John, and maybe I'll work my way backwards. We develop in our paper, part 3 of our series, on John Adams' oath at some length. But instead of talking about John Adams, I want to talk about 2 positions that are not very important, which is the Clerk of the House and the Secretary of the Senate. Okay? Look at the Article 6 Oath Clause. I have it on the screen right over here. It refers to members of Congress and executive and judicial officers of the United States. Where would the clerk and the secretary of the Senate fit in there? They don't, right? They're not executive officers, they're not judicial officers, they're legislative officers. They're not senators, they're not representatives. So the very first oath statute, the one that John mentioned a minute ago, provided for the oath for the clerk and the secretary of the Senate. The statute referenced Article 6, for sure, it did. But the oath for the clerk and the secretary of the Senate cannot be from Article 6. The only basis for the oath of the clerk and the secretary would be the Rules of Proceedings Clause. I was like, whoa, Josh, you have to do it through one House resolution. You don't have to. Congress can pass a statute pursuant to the Rules of Proceedings Clause, makes it permanent. It's bicameralism presentment. The first statute, this is the very first statute that George Washington signed, refers to the President of the Senate. It doesn't say the Vice President, it says the President of the Senate. He was a legislative officer. The very same clause in which the Secretary of the Senate's picked, it's referenced, you have the Senate President pro tempore, right? And in other cases, it's the President of the Senate, all right? So we think the best reading of this is they didn't know what was going on, right? They kind of got there and said, wait a minute, what about the Vice President? John Adams has said this is the most useless position ever created. It was an afterthought late in the convention. Article 6 doesn't squarely cover the president, but thankfully we have the Rules of Proceedings Clause to cover it. So this is actually, I think, what Jonathan Mitchell was afraid of. He didn't want to talk about the VP. He never mentioned the Oath Clause. He never mentioned it once. I think this is the exact reason why. He didn't want to give this argument. Maybe he found it like John McCullough, an academic, didn't find it persuasive, perhaps. Lawyers have different duties, but he didn't find it persuasive. All right. The Commissions Clause was the other clause that John mentioned. And we've known about this for years. In fact, there's actually an OLC opinion on this saying that you do not need a commission to be an officer of the United States, right? So this is not anything new. Look, the Constitution says something, and then something else was done, right? It says the President must commission all officers of the United States, not all the ones he appoints, all the officers of the United States. Perhaps it was just deemed too burdensome or otherwise? We don't know. We've never led with the commissions clause. A lot of people think this is actually the strongest one. In fact, Mitch will keep mentioning it. We haven't led with it. We lead with usually the oath clause or the appointments clause. Okay? I already did. No, Jed asked me about the appointments clause. Let me get to the question from my good friend Larry, who always, I think, asks just such thoughtful questions. I think you got the flip side exactly right. We are basically two sides of kind of the same coin. Original methods may be useful for us. I know there are people here who adhere to that. I think it's a useful doctrine to think about. But when we're talking about qualification language, I think you need to be a little bit more careful than just saying, what would the man on the street think? What would the average person on the street think? And the reason we know this is that there were debates in Congress about the oath clause. I'm sorry, the ironclad oath statute. And how did they decide how to understand the ironclad oath statute? They went back to history, right? They looked at the Blount impeachment trial, which was also asked about, right? They looked at some of the early sources. In order to decide what this language meant in the 1860s, officer of, office under, they looked back. And we know during the Blount impeachment trial, people sort of said the things that Tillman and I said. Not exactly the same, but in the same ballpark. It was a different case. So whether it's original methods or otherwise, we have this language. We're making a very momentous decision whether to disqualify someone from office. And I think it's extremely relevant and indeed useful to try to be exacting, right? Perhaps if this is, a Bill of Rights case or a 14th Amendment case in due process where it's kind of more fluid and more open-ended, we can ask people thought about liberty, ask people thought about the Second Amendment and so on. But I think here, text matters. Now, I'll sort of anticipate the question to Will. How do you resist this technical reading? On office under, I agree, in the 14th Amendment, it's drifted, right? There is drifting that happens. But when you have decades upon decades of precedent saying officer of the United States means appointed and there's no contrary authority, it does become harder to resist. And I think this is what the trial court in Denver realized, that there's a lot of authority on this side, some on the other side, and she found our side more persuasive. I don't need to persuade you that we are the absolute best theory in all regards. I don't think I can persuade anyone with that. But I think we've cleared the bar. This is not some sort of secret, unknowable code. They need a decoder ring to understand. Will, tell us why we need the ring.
All right, so first of all, secret codes are knowable. If they were unknowable, they would just be gibberish. And I have not suggested the argument's gibberish. Larry, it's a great question. And for the most part in writing this article, the differences in detail between my co-author's original public meaning originalism and my original law originalism didn't matter. But you're right that I may have more patience for Tillmanism because of original law originalism than somebody with a more conventional original public meaning approach. That said, I think that is the strongest for the original Constitution, when you can at least make a more plausible case that there's some original law principle that would tell you to harmonize all the rules. Although I'm not sure there was. I'm not sure anybody's shown this. In James Madison's famous, rules for right interpretation in his bank speech, he says it's not pretended that every insertion or omission in the Constitution is the effect of systematic attention. This is not the character of any human work, particularly the work of a body of men. And so I think actually it's not obvious that there was such a principle, but if there was, that might make sense of Tillmanism in 1789. But again, I think it's pretty, there's not much evidence of it in the 14th Amendment context. And even the things like Story and various cases talking about officers of the United States are all talking about its meaning in the context of a particular clause. They aren't then saying, the answer for this clause is the iron anchor to all other clauses that use the same word in different contexts, which is the thing you'd need to believe to Tillmanize officer of the United States in Section 3. Mike, one thing on this First Amendment question, I think we're in the first category you described, that is, we think you should try to read the First Amendment and Section 3 together, but to the extent you can't, Section 3 is the one that controls. I think there is a sentence in our paper as I reread it after your question that might be read the other way, where we say that where the best reading of Section 3 is inconsistent with the First Amendment must give way. And if we meant the best reading of Section 3 in isolation, ignoring free speech principles, that might make it seem like we're just saying, Section 3 always repeals the First Amendment with no consideration of free speech principles. But I don't think that's what we meant by best reading.
Pulling back the curtain a little bit, we had very few disagreements as we were hammering out what to say in this article. But one of the areas where we had subtle disagreement was I'm considerably more impatient with the officer's argument, and Will is a little bit more indulgent of it. Let me just explain the reasons why I'm impatient. And I think this kind of goes to some of the things that Cy's paper was addressing. I think that context matters, that the overall sense of the terms matters, and what would be a plausible understanding matters. You know, the objective public meaning and understanding. It is persuasive to me that, you know, I'm not usually a huge fan of legislative history, but when a piece of constitutional legislative history speaks specifically to a question, that can be pretty good probative evidence of meaning. And when we came across Reverdy Johnson's inquiry about whether president is covered, you know, it really is quite striking. I think, I don't remember what page of this article it is, but Reverdy Johnson is looking at the final draft of this, and he asks Lot Morrill, he says, hey, you screwed up. This text doesn't cover the president. Of course the president and vice president have to be covered, and you didn't cover it. And Lot Morrill interrupts and says, look at this language, officers of the United States and officers under the United States. And Reverdy Johnson says, oh, never mind. And, you know, I was probably wrong about that. I find that very probative and persuasive. In general, while you should read the Constitution carefully and attend to actual terms of art, you got to be careful not to invent terms of art when really what is going on is that some of the language of the Constitution is imprecise. I think that the Tillman-Blackman officer argument is ingenious, but ultimately implausible. I think that it doesn't make sense of the text if you look at the text in context. Quick word, Michael is left. Oh, he's still there. I think that's a very thoughtful question. The First Amendment implications were the parts that I found as we were writing this potentially most troubling and difficult. I remember asking Jack Balkin about it last year at this conference, picking his brains on it. And the principles we settled on is that where the two principles, the First Amendment and Section 3, can be harmonized, they should be, right? And that's really easy to do in almost any circumstance you can imagine, because Section 3's description of what constitutes insurrection or rebellion will not reach most First Amendment protected activity. In addition, the First Amendment is not absolute and doesn't reach things like conspiracy, facilitation of crime by speech, solicitation, and attempt. So I think that these issues really don't arise very often. And that's probably our safest answer. When push comes to shove, if Section 3 means in some of its applications things that are contrary to modern First Amendment doctrine, we go with Section 3. I think that's right. And I think that we do not adopt a construe to avoid conflict principle other than to the extent that I'm generally not a fan of adopting the second best reading of the Constitution or of any constitutional provision in order to accommodate some other thing.
So this is a different kind of question and kind of an unrefined one, but hopefully not inappropriate. So I thought, you know, all these papers were really impressive. And, but I wondered whether, and this is primarily addressed to, I think, Will and Mike, someone might say, this is a paper where the more persuasive your specific arguments are, the more it might tend to discredit the approach you take to these kinds of questions. So just to sort of elaborate a little, you know, if we were sort of thrown into a culture where they tried to resolve major political, you know, questions, constitutional questions by astrology or by some sort of Kabbalistic method in which they count up the magical numbers of letters and so forth and see how it adds up to, we'd probably say that's really weird. And even if the arguments are extremely sophisticated, say, why would they do that? Because it seems kind of nuts to us, probably, because we'd say it doesn't seem to reflect any kind of really application of mind to the particular serious problems you're trying to resolve. And of course, in their worldview, maybe it there would be some explanation for how it does that, but to us at least, most of us, we'd say that. So, of course, people make arguments like that, also that kind of criticism of constitutionalism generally and of originalism, dead hand type arguments are kind of along those lines. Why would you resolve major questions by looking at what people who, died 2 centuries ago said? And I think there are pretty plausible responses to that kind of criticism for constitutionalism and for versions of originalism. But when you have a really highly formalistic, I would say, originalist approach, I wonder whether that criticism starts to have some bite. So, one place where that might come up with Rappaport's question, would be sort of maybe a version of that. But if you start even with your first claim, is Section 3 applicable to this sort of question? Now, if somebody asked that about, say, the due process clause. It seems to me it would be quite plausible to say, even though it was adopted, the Fifth Amendment, centuries ago, a couple centuries ago, it did reflect an active mind of people thinking about perennial problems and trying to figure out what sort of general approach would make sense to those. But if you say the same thing about Section 3, it comes across as what we're pretty confident of is here was a very, in some ways, local, situation, quite unprecedented in some ways, with people thinking primarily about that problem and giving probably very little thought to adopting something that would be, and then your answer to that, I take it, and this is your first point, is so, well, that's what the words say. And I wonder whether, so maybe they didn't really think much. And maybe, if we think, are we going to decide now whether someone should be eligible for president? This might seem like kind of a bizarre way to resolve that question. And I think your answer is, but if you just read the text, that's what it says. And I wonder whether you have any concern that that kind of might, as I say, discredit the whole approach, even, and more so to the extent that your arguments are persuasive.
So my question is largely for Josh and his co-author in his absence. You said in your presentation something about the Heilpern-Worley article presenting no evidence, and forgive me, but you talked a little bit fast and I didn't quite follow, but if you could lean into what they present no evidence of, because my reading of their article indicates that they have fairly solid corpus linguistics evidence that officer of the United States was not a legal term of art. And they also, irregardless of that, cite the Postal Act of 1799 listing the president as an officer of the United States. So I was wondering what the response was. There was also some discussion of the word on the street and dissing that a bit. Isn't that coterminous with original public meaning as long as it is contemporary? And don't we want to look at things like corpus linguistics to help us understand how things were understood at the time? So leave it at that.
Great. Just a short question for each of you on the sensibility question, because you both have great text historical arguments. And so on the sensibility, Josh, you didn't in your presentation talk about this, and I think it was mostly Justice Alito who talked about the holding office question versus running for office. And can it really be that we have to wait till the end, or would that be total chaos? So ask the Justice Kagan question, but not about is the president included. Can we really wait till they're holding office? And then, because it would seem to lead to chaos. But Will and Mike's also leads to chaos, I think. And so my question for them is, if you truly believe that this is self-executing, suppose the Supreme Court rules against your position 9-0, but last I heard you both believe in departmentalism. So on January 6, 2025, if Kamala Harris refuses to certify Donald Trump as the president of the United States because she took an oath and she believes him to be disqualified and she believes that the Supreme Court got the Section 3 case wrong, has she committed insurrection? Yep. And if not, is John Eastman off the hook? I guess that's how.
I didn't hear the last.
Oh, I said, and if she's not guilty of insurrection for that, is John Eastman off the hook? You can ignore that last aside. It was just.
Can I start off? Let me address Steve Smith's question and Ilan's. Steve, does our article disprove originalism? I'd love to think that this is the article that broke originalism, right? You know, that because the logic of our reasoning is so persuasive that if you're an originalist, it leads you to disqualify Trump, but we can't possibly disqualify Trump, therefore we're no longer originalists? I'm trying, I want to say that in a sense, Steve, you don't really believe in law, right? If you believe that the text of the Constitution and its original meaning is law, this part of our article, and this is a classic Paulsen shtick, is to take something and like follow it to its logical conclusion. I think the answer, and this is far less crazy than some of my other positions, and I credit Will Baude for that. But I think if this is the logical consequence and deduction of originalism, that the courts should follow it and other officers should follow it. It was interesting to me in listening to the oral argument Thursday. I was talking with Will about that. I said, did they ask any questions about the meaning of the Constitution? Or were they just raising consequentialist questions about its implications? So I wonder, part of the reason I speculate that our article got such attention and traction is that it is directed square at the methodologies of Clarence Thomas, Neil Gorsuch, Amy Coney Barrett, to a lesser extent, John Roberts, Sam Alito. And I think what caused it to get some attention is how do the conservatives, the originalists on the court, reconcile this with originalism? And I think that's a real problem. Okay, Elon's hypothetical.
Hypothetical.
If the Supreme Court rules against us, does that bind other actors in the system, right? I'm about as pure a departmentalist as they come, and part of what we were arguing in the paper is that there are multiple interpreters who at multiple different points each have an independent obligation to enforce the Constitution. As long as you are exercising a power that is actually open to you under the Constitution, we say so secretaries of state should exclude, state election boards should exclude, they should enforce, state courts should enforce, Congress should impeach, Congress should exclude or expel members whenever there's a violation of Section 3. When we address the question of the president, we say electors should not vote for someone who is constitutionally disqualified. What if all of those go wrong and you have this is a substantive question about whether the 12th Amendment confers upon Congress a power to reject electoral votes cast on the grounds that they think they are unlawfully cast. In the end, we do not read the 12th Amendment that way, right? Congress has a plenary power to judge elections and returns each house of its own members. And there is, the 12th Amendment just is a provision that says you meet, the certificates shall be opened and counted, right? It's like full of the passive voice. We do not read that as authorizing Congress to reject votes. However, right, if, we lay out the arguments on the other side. I think we did this in our last of a 10-part blog series. Was that just posted yesterday?
Yesterday.
I think it is a recipe for a constitutional crisis if the Supreme Court says that Trump is not disqualified. I guess it depends on the ground what they say, right? The question is there a way for them to say that Colorado can't do what it's doing that would also prevent Congress from enforcing what it understands to be a disqualification. If they're looking for off-ramps, that's not a good off-ramp to say, let's see what happens on January 6th. And so it's a great question. I think it is a recipe for chaos for them not to decide this issue.
I want to add two quick things. Sorry, son. Yeah. Two quick things.
You're on.
Am I on?
Yes, you are.
I am. Okay. I think Alon's question also raised the vice president question rather than just Congress. And I think while it's at least arguable that Congress has a role to count the electoral votes, there's no non-frivolous argument that the vice president has a role to count the electoral votes. So, and that may be much less likely as a matter of where will Congress be and what will they do. So unfortunately, I think John Eastman is still on the hook. And one thing to Steve, I think you might be selling the mindlessness of this argument a little short. So one version of Section 3 explicitly applied only to the problem at hand, the late insurrection, and expired in 1870. And this was roundly criticized as unprincipled on the argument that constitutions should contain enduring principles rather than one-time political measures. And this made the whole thing feel dirty and wrong. And so one of the responses to that criticism was to take that out and to turn it into a general principle. So I think if the adopters of the principle felt it was important to them to adopt a general principle that applied beyond the case at hand, not anticipating what would come, it's sort of doing them a disservice to say, well, I know you tried to speak in general terms, but you're not really allowed to do that. You're really only allowed to concern yourself with your day-to-day. We're sort of not allowing them to be principled, which I think would be wrong.
I'll address the corpus linguistics point. I like corpus linguistics. James Phillips, my friend and I, have done a very thorough study of the Second Amendment in corpus linguistics. I think a problem with corpus linguistics in this context is the queries, right? Basically what they do is they search for office and officer within a paragraph of the president, and you kind of see what you find. The problem is they find stuff they don't quite know how to interpret the results. So Lorianne mentioned the 1799 Postal Act. It's a statute, true, and it says officers of the United States and lists the president. It also lists members of Congress. Everyone agrees that members of Congress are not officers of the United States. They can't be. Incompatibility clause, right? That can't possibly work. They're not appointed by the president. They receive commissions. They can't be impeached. Maybe they can. But I think everyone mostly agrees that you can't have a member of Congress and an officer of the United States. What does that show? In a statute, you can use the word differently than used in the Constitution. Congress can do that. When you randomly search colloquies during the 14th Amendment's debates and so on, and you see the word officer and the president in the same paragraph, you assume, aha, they thought the president was an officer. Well, that's officer, not officer of the United States. The Halpern and Worley paper, which got a lot of publicity, makes a point that in the debate over the 14th Amendment, they did not find a single reference to the president as an officer of the United States, period. With other surrounding adorning language, perhaps, but not the key phrase, they didn't find it. So I think all the studies by Velopoulos and Graver and others show that the president was an officer, which we don't disagree with. But of the key phrase, officer of the United States, there's not much. Office under, they got stuff, right? And this is why Tillman recognized this more than a decade ago. But an officer of the United States, they don't. I do want to address the Elon hypothetical. Seth and I had never put weight on the holding office part. In fact, I think we actually agree with Will on this point. If Colorado has to appoint electors, right, and they don't want their votes to be wasted, and they're choosing qualifications in an earlier juncture, in the abstract, they could decide to do this. Now, we think the problems with execution, which is separate from the holding office point. In fact, these things overlap. But I would not favor waiting till Inauguration Day or, Lord help us, January 6th of 2025. We saw what happened the last time. And let me just sort of lay this out very clearly. Let's say that Trump wins the Electoral College, but there's Democratic majorities in both houses. It's not Kamala Harris making the decision. Under the procedures of the Electoral Count Reform Act from 2023, basically both houses of Congress cast a vote, and if they vote to knock out a vote from Alabama, and then Arizona, and then Arkansas, I'm getting the right order, right? They just go down the list, and then Trump doesn't have enough votes. What happens? Well, this actually isn't clear. Does Trump's VP become president, or do they have a basic contingency because no one got a majority, then Biden becomes president, or maybe Joe Manchin, who's going to be in the top 3, becomes president? There's lots of chaos that can happen. So I hope the court, which is not listening to us now, does not take an off-ramp. I think the arguments that Seth and I advance are silver bullets. It would end this. And I think if, God bless, Ketanji Brown Jackson, Neil Gorsuch say the president's not an officer, I think that ends this, right? Even if the Chief Justice does his little blue plate special and makes something up, right? If we get a concurrence from, I'm serious, He'll whip it up, another Obamacare, the president's attacks, right? Whatever, right? If Justices Jackson and Gorsuch, write a concurrence, Larry's laughing. If Gorsuch and Jackson write a concurrence saying the president's not covered, citing either me or Kurt Lash, I think that ends this. It's over. If you can't get Ketanji Brown Jackson, you're not going to get this on departmentalism. So we'll see what happens. Maybe by the time this recording is released, we'll have a decision. I'll look prescient or look an idiot. I don't know, but we'll have it on there.
Hi, I have a question for Josh, and it's about original public meaning and the president being an officer of the United States. And my question is, your article really leans heavily into comparing language between the Constitution of 1788 and then a language of the 14th Amendment. I just wonder, was the original public understanding of the presidency the same in those time periods? I mean, 1788, we were coming up with a new type of executive office, a president who would not be king, who would be under the law, who could now execute the law. And I think in that context, because this was a new type of office, isn't it more important in something like the impeachment clause to specifically mention the president as an officer who could be impeached, but perhaps by the time of the 14th Amendment, the president was not so novel, was not so special, and might more easily be lumped in with other officers. So I just wondered what your thoughts are on that argument.
Thank you.
I'm sure Seth has written about this, or you've written about this somewhere. I didn't notice it in this particular paper, but could you just walk us through why disqualification from holding office under the United States for being impeached? I mean, is it just that, no, it doesn't apply to the president, or because that seems odd. Sometimes the Constitution has things that are odd, but that does seem odd. And then Will and Mike, I think Kurt has argued, or at least Kurt argued in his amicus brief, that this is kind of, there's a lot of ambiguity here. It seemed like there was an argument in oral, or a theme in oral argument a little bit, that in an issue like this where there's ambiguity, maybe we should err on the side of allowing people on the ballot, kind of an err on the side of democracy type of an argument. That sounds like a substantive canon that doesn't formally exist. What is your response to that? Is it just that, well, we're originalists, we don't care about substantive canons, or this is not a real substantive canon? We care about substantive canons that might have existed at the founding, but not this one that seems like it's made up, even though my understanding is that secretaries of state kind of informally do this, that when it's a close call, they allow the person on the ballot. So any thoughts on that?
My question is somewhat similar to James. Before jumping into that, let me just thank you all for the great papers, and also for getting so much of America excited about originalism. It's a real contribution. So related to what James was saying, I'll direct it to Michael, to you, but also interested in your thoughts about this, Will. Michael, in your article about does the Constitution prescribe rules for its own interpretation, you have this passage where you talk about basically the clearer or the more specified text is, then the more that provides grounds for constraining democratic choice. But as it's more open textured, or there's more room for debate, the more room we should leave for democratic choice. And I'm wondering if maybe sometimes the principle can also work in reverse. Like, the bigger the impact this is going to have on undermining democratic norms or democratic processes like the presidential election, the more we should be really, really, really confident about our interpretation of the text. And so I'm curious if you think anything like that principle might operate for an originalist, number one. And number two, I'm just curious if you had to give like a percentage, are you guys like 75% sure you're correct, 99% sure you're correct, 100%? Like, is there room for epistemological humility where the consequences are so significant for our country?
Oh, can I start with that? We are 100% convinced, and I say that with all epistemological humility. And actually, when we have conversations with people, I had one yesterday, where the question was, what ground will we lose on, right? Because we will lose. This seems to be the common assumption. The only thing that gives me hope is that it is hard to write up the rejection of our answers, right? That we think that it is possible that as they go through and analyze the issues, most of the off-ramps and silver bullets really don't work. Okay. Let me briefly address, since we're here, James's questions, right? And you talked, here's the point I wanted to make, yeah. If you adopt the view that the president is not an officer under the United States, right? Then I just want to emphasize it means that he can't be, that an impeached, convicted, removed, and disqualified president can be disqualified from everything other than being president again.
In Congress.
Yeah, and that's kind of wacky. And there are a number of other problems with this analysis of officer under, specifically. I mean, the president could be an elector in his own election. The president could also be senator, and I think Seth actually embraces that as the correct answer to the Constitution. This goes both to James's question and Stephanie's question, and to epistemological humility. I don't think there's any ambiguity here. I think that the answers supplied by the text are actually reasonably clear. And we have a couple of blog posts on Volokh responding to Kurt Lash's use of legislative history. I don't think that you can use legislative history in a dubious fashion to generate ambiguity if the text is clear, okay? And I think we make that argument. As to democracy being a substantive canon, there are a number of provisions in the Constitution that limit democracy, right? That impose qualification restrictions on who can be an officer, okay? And this is of a piece with those. Is the I can't vote for Barack Obama or George W. Bush again. Is that anti-democracy? Most people would say, no, that isn't anti-democratic. That's just how our system works. If Section 3 imposes a legal disqualification, and it does so reasonably clearly on the facts as established and found at trial, that is part of our functioning constitutional democracy. It is a limitation on direct democracy, just as the Electoral College is. If you believed too strongly in a substantive canon of democracy, you would say that Hillary Clinton should be finishing out her second term right now because she won in 2016. But that's just not how our constitutional system works. If Section 3 imposes this disability, that is part of our Constitution, and that is a limitation on democracy. And others have made the argument that Section 3 exists in substantial part to protect a functioning democracy. So just wanted to make those points.
So I think it's true there is in state election law, this like democracy canon sometimes used in interpreting state election law statutes. I have not fully nailed this down. I'm thinking about becoming an election law scholar with Steve Sachs because the world seems to need them. But from what I can tell, it does appear to be a 20th century thing, that the norms and assumptions about suffrage and democracy in the 19th century are very different. And of course, the assumptions of Section 3 itself are very different. So I think it's pretty anachronistic to read Section 3 as if it were just a modern election law statute. I think the general questions about like stakes and like, should we just have to be extra sure given the consequences here are tough because the consequences cut both ways. And that was true even of the early Section 3 debates, and Chase says, look, it's unthinkable to disqualify people. And meanwhile, Judge Underwood says, well, I don't know, I think it's pretty unthinkable to let all the rebels just have power again. And so it's hard to know which way those cut. If we had to put a thumb on the scale, and I'm more of a fair and balanced guy, but if we had to put a thumb on the scale, the fact that Congress has the amnesty power and can easily cure over-inclusiveness in any case where that's not extremely controversial, I think might lead us to just err on the side of putting things in Congress's court, if I had to have one. And unlike my weak-kneed co-author, I am 10,000% sure.
Let me address James's point. And this is actually separate from the Section 3 question, because again, Tillman has long ago not taken a position on whether the president's in office under Section 3. But there are 4 clauses in the Constitution that use the phrase office under the United States. And these are the ones where we get the most pushback. In fact, I think Mitchell's fear of this led him to take a position that he did. The first one is the election compatibility clause. The concern with this provision is that people would exercise power. So, for example, you couldn't have some appointed position who has a superior telling them how to vote. This is about decisional independence, which perhaps was rejecting Schiaffolo. I don't see a problem with the president voting from the Electoral College. The president votes every year. We know goes to the ballot box. It's always a photo op. That one doesn't bother me very much. The incompatibility clause, I think, is misunderstood. Today, it's often viewed as a separation of powers provision, and that's just not the case. There was an incompatibility clause in the Articles of Confederation. We had no separation of powers there. There's an incompatibility clause in the British tradition. It's a very different system. The idea was that the king, the crown, could not appoint members of parliament to executive branch positions. Almost like a cronyism thing, right? That we're not going to appoint people to get favored legislation. We had the same provision in the Articles of Confederation. We didn't have a separation of powers. So the thing is not that the president serving in Congress, is that the president cannot appoint people who are in Congress to cushy executive branch positions. That's a prohibition. I agree, it's unseemly for the idea to have the president serving in Congress. There might be some very good reasons why that doesn't happen. It's not the incompatibility clause. Impeachment disqualification clause. Right. This says that if you are impeached and convicted, and again, conviction requires a 2/3 vote, you can then be disqualified from holding a future office under the United States. Convictions 2/3, disqualifications a simple majority. Okay? We think the fear here was that a person, for example, might be impeached and the president immediately reappoints him to another position to bring him back to the government. That is prohibited. But with election for both members of Congress and the president, the people get to decide. Let's say that there's a rogue Congress that with fleeting majorities impeaches the president and disqualifies him from the future. They have their own political ambitions. They want to run for president, right? Why should that decision bar further the people the right to choose or elect representatives? Alcee Hastings from Florida was a federal judge. He was impeached and convicted, but not disqualified. He served in Congress for 20 years because the people of his district thought this is wrong. The impeachment was wrong. He committed bribery, but it was wrong. I would let the people decide, and not a fleeting majority in Congress. Let's say that in 2021, Congress impeached and convicted Trump. A lot of those Republican senators aren't in office anymore. They may not represent the will of the people. Let the people decide. This is not so weird for me, James. And then my favorite, we all come back to the Foreign Emoluments Clause. Seth and I actually wanted to go to Mount Vernon to take a picture with the key, but actually Mount Vernon doesn't allow photography. It's actually very high up. You can't do professional photography, so we didn't do it. The Constitution prohibits bribery, right? Bribery is still an impeachable offense. If you accept gifts as a bribe, you can be impeached. Okay. Why might the president be exempt from the Foreign Emoluments Clause? He has foreign powers. The act of receiving gifts is an act of recognition. And you don't believe us? Read Zivotofsky. There were actually gifts given to the president from republics in South America. And the purpose of the gift was to recognize their nation. And James Madison said, uh-oh, I can't accept this gift. What am I supposed to do? And members of Congress said, no, we want to recognize this republic. So Madison sort of kept it quiet. And then somehow we think we're not exactly sure, the gift went to Monroe. And we're not really sure what happened after that. The act of recognition is closely tied to the acceptance of foreign gifts. I can explain why the president's exempt, but I would always turn to our good friend Alexander Hamilton and the documents showing the president's on office under. Even if the consequences seem, as Gorsuch said, a little odd, this is how the document works, and it's a text we're stuck with and not modern day sensibilities.
Thank you very much for these, just extremely interesting papers and conversation, and I've been interested in this the last several weeks. On the presumption of democracy, just 2 points to suggest it should be read at least in that way. Although I'm Tillmanized, I also think it's really ambiguous, and this is a tough one. And I just also to rehabilitate the issue of Reverdy Johnson's remark, I think it cuts both ways. It's really, the conversation itself is ambiguous. The fact that the Section 3 seems to me sensibly to not include members of state legislatures strikes me as part of the whole, the move in Section 3 when they repudiated let's disqualify voters, but instead let's disqualify certain high officers, that they maybe were thinking state legislatures ought to also have a certain flexibility because they're so close to the people. What that means for presidency is a different question. But and the second thing, and this is outside the scope, and I'm going to say it real quickly, I'd love someone just maybe privately to explain to me why I'm wrong. Section 3, disqualification, is for a culpable offense, something bad. You did something bad. Section 2 identifies it as a crime. Article 3 says all crimes shall be tried in only 2 ways, by jury and by impeachment trial. And in Ex parte Milligan, the Supreme Court dealt with what happens when those things aren't available, and Chase is very emphatic. Congress can decide it. And this is simply Griffin's case, is that Congress has to set up the alternative mode in the cases where Article 3 breaks down.
Thanks very much for your papers, and I have a question for Mike and Will. It's about the original meaning of engage. So I think I understand you to say that the part of Section 3 that says aid and comfort to enemies expands the idea of the engagement. I'm inclined to think the opposite, though, and I'm going to see what you think about this, that I think in the 19th century that enemies was understood principally in a military sense. And there's Supreme Court cases and statutes from going all the way back to the founding where enemies is used in that way. And so it seems to me that perhaps the enemies clause is actually saying in what sense an aid and comfort is brought within Section 3, and it is when there are in a military type situation. That would seem to suggest that engage itself is actually a narrower meaning that does not include aid and comfort. And that might suggest that engage has a connotation more of direct involvement. Whereas, so you engage in insurrection, you're under Section 3. And if you engage or give aid and comfort in a military situation, then you're under Section 3. Suggesting a somewhat narrow meaning, I think, of engage than what you're working with. And then I just wanted to also add, somewhat channeling Mike McConnell, who couldn't be here today, that my understanding is that then if you look at the way Section 3 was applied by Congress in the immediate post-ratification, that they also read it, the engaged part, somewhat narrowly to mean active involvement as opposed to aid and comfort type activities. And so I don't mean by this to be suggesting anything about the actual conclusions about how this applies to Trump, because I just don't really know the facts well enough. But I came away with the impression that perhaps you were pushing the meaning of engage further than either the text or its application in the immediate post-ratification period would warrant.
Question for Will and Mike. You argue that the disqualification just is as soon as it's triggered. The question was raised at Supreme Court oral argument. Does that mean during the last 2 weeks of Trump's term after January 6th, he was disqualified? Does that mean his actions didn't have legal effect, analogous to an officer serving in violation of the Appointments Clause, where you could challenge the actions taken under them during their term, even if at the time people thought they were lawfully serving? The lawyer for the challengers said, well, the de facto officer doctrine might apply, but that seems like it's been disfavored, at least in Appointments Clause challenges. And it seems like you could make an analogy to what if a president started their term and then you found out he lied about his age, he was 34 for the first 2 weeks, or the president didn't take the oath correct the first day and did an action that could be challenged. That happened to Obama on the first day. He messed up the oath and he took it again the second day to make sure all of his actions would be legal going forward. So I'm wondering, do you agree with that those might be vulnerable? Do you think a challenge could be brought? And if this case at the Supreme Court is decided not on the grounds of disqualification, if they don't reach that question, could a challenge to an action during the last 2 weeks actually raise the legal issue in a cleaner way?
I'll offer a few thoughts and let Mike clean it up. I'll just say on crime, everybody who looked at how Section 3 would apply and did apply all thought it did not require a criminal conviction, and part of the point of enacting Section 3 was so as not to have to kill all the Confederates. I think that's pretty clear from the text of it. It is true Section 2 refers to rebellion or other crime, although not insurrection, but that's how everybody thought it worked. I have just two things to say on engage that I think our friend Michael McConnell might have missed. One is Attorney General Stanberry, who wrote an opinion about the Reconstruction Acts that discusses at length the construction of Section 3, and in general is seen as sort of on the more strict construction, narrow construction side. Nonetheless, says repeatedly, and this is quoted in our paper, that in his view, the engage in language, not the aid and comfort language, the engage in language includes any overt act for the purpose of promoting the rebellion, including merely speech acts such as inciting rebellion. He specifically says inciting rebellion, and he specifies, to be clear, persons may have engaged in a rebellion without having actually levied war or taken arms. Whenever an act is done voluntarily in aid of the rebel cause, it counts as engagement under the rebel clause. And similarly, I think if you look at the exclusions of people like Lewis Mackenzie, or the debates whether they could be excluded, in the debates, they seem to recognize it. He gave pro-secession speeches before secession had happened, and then there was a debate about whether he'd done several things, and they sort of credited on the facts that he had been a relatively unionist person once secession happened. But I think if you look at them, they don't suggest the sort of that kind of narrow construction. The de facto officer doctrine is a really important doctrine that Justice Gorsuch apparently does not entirely understand, and that was much broader than what the court's 1980s and on separation of powers cases suggested is. Exactly how broad it is, whether Chief Justice Chase is right about its scope in Griffin's case or not the self-executing part, the de facto officer doctrine, is really interesting, turns in part in the original scope of quo warranto. I will just, one piece of evidence, Blackstone points out that in England, it was considered high treason to kill a usurper who was pretending to be king. Even if they were not the king, if they were merely a usurper, if they held the office as usurper, they were supposed to be treated as the king for purposes of criminal law. Whether those kinds of principles still extend to the president today is plausible, but I think we'll take another article.
Let me just add a couple quick thoughts on enemies. I think that's a really good question, Mike Ramsey. What we found in the historical evidence in the 1860s is that the idea of enemies was clearly understood to embrace secessionists generally, right? Things, and it's not necessarily limited to people who actually bore arms. The ironclad oath is what introduced the now familiar idea, you swear an oath to support America against all enemies, foreign and domestic. I think originally, enemies might have had the meaning of somebody who is affiliated with a foreign government. I think the term enemy now can include domestic enemies. As to whether aid or comfort to enemies broadens or narrows engage, I think we actually contemplate that in aid or comfort to enemies might have a narrower meaning, but I think the overall context of the language indicates that they were trying to be comprehensive and to avoid loopholes, and that the aid or comfort seems to reinforce the idea that engage can consist of more than direct engagement. And we analyze the evidence of what was considered engaged directly. But I think that's a very interesting and important question. Is Trump disqualified the last hearing? I had this conversation with Jack Balkin over breakfast yesterday. If I commit murder, I am a murderer. And as a matter of law, I am a murderer. But it still requires somebody to bring the law to bear in a particular case. So I think that the better answer is that Trump was legally and constitutionally disqualified by virtue of engaging in insurrection or rebellion, certainly no later than January 6th.
What time?
It might have, I'm going to leave that said. I think he's legally disqualified at that time, but to effectuate the application of law to that situation requires some sort of process. The processes we identify in our paper are the 25th Amendment, possibly, and impeachment. As long as the pretender president continues to hold office as president, he can be legally disqualified, but that legal disqualification not effectuated fully by the legal process.
I think I'll respond briefly to the appointment of the state legislatures. If you look at the text, in the disqualification element, state legislatures are not expressly listed. But in the oath element, it refers to members of state legislatures. Now, again, we think that what's labeled number 1 there is from the Article 6 oath clause, because in Article 6, members of state legislatures are expressly covered. But in the disqualification element, they're not expressly covered. There were extensive debates about whether members of state legislatures held office under the state. There were debates about this. Will and Mike cite some authorities. People didn't agree. I think this shows that the waterfront was not covered. And to Justice Jackson's point, they used language that didn't sweep in everybody. They missed some people. Having the president was, as Justice Jackson said, maybe not on their minds. David, I'm glad you've been Tillmanized. The Reverdy-Johnson exchange, I think, does cut both ways. I think Curtis made this point. Maybe you don't agree, but I think it's there. And with regard to at what moment in time Trump became disqualified, it's actually a hard question, because if he was disqualified, then he could not dispatch the National Guard. Right? If he wasn't president, there was nothing for him to do. So perhaps one of the allegations that he became disqualified is he didn't take enough action, but he was already disqualified, so he couldn't take those actions. So it's almost this sort of, you're in this death loop as well.
This is the end of the panel, but I think we can all agree that these are some scholars.